Hello class, good morning.
Good morning
Good
po.
morning po.
Perfect. Now, how is your energy? Kumusta? How is everyone?
High energy, sir.
Sige, let me ask you, no, sige, let me start this with a prayer. No, is it okay? No? I'll lead the prayer. No? Lord, thank you so much no, for giving us the gift of life, love, friendship, family, and wisdom. Amen. All right. No, so, class, no, let me start this with my usual check-in question. What are you grateful for today? Napakahirap ng tanong ko, no? Sige, Claire, go ahead.
I'm grateful po sa lechon na ibibigay ni Miss Kat. Tapos po sa events place na sasagutin ni Kuya Ronan Mendiola po, sir.
Wow, amazing. Bakit nga ba may mga lechon sa events place ka, Iha? Anong meron? Birthday mo?
Mag-host po si President Bautista po ng Christmas party.
Wow, amazing. So magkikita-kita kayo?
Sir,
Yes
sama ka.
po.
Join po kayo. Join ka, sir,
Wow.
from Mindanao.
Pwede naman. Pupunta naman ako ng Maynila. In fact, I think tomorrow is my flight, no? I have a flight to Manila. Okay, sige. Thank you so much, Claire. No? How about you, Keen? Go ahead.
I'm thankful for the opportunity na nakausap ko isang seller kahapon and sana ma-close deal siya.
O, 'di ba? Gusto natin 'yan, no? Kasi kumikitang kabuhayan, 'di ba? Okay, thank you so much, Keen. Anyone else? Last one? Meron pa? Lana? Okay. No? So, Cyrus, go. Close deal. No? Ano na close deal mo, Cyrus? Rental. No? Rental agreement. Magkano yung charge mo being the, the salesperson? Ganun. Sa kanya. So, hindi mo pa alam kung magkano. Sige, class, para at least alam nyo rin, no? What is the usual, magkano yung ating commission pag halimbawa, rental?
1 month.
1 month, sir.
If 1
Sir,
year,
may question
1
din po
month.
May cases, sir, na 1 month and half month or succeedingly.
Ayan. So, at least alam nyo. Wait, bakit nag-add? Feedback? Yan. Feedback pa rin. Okay. Sige. So, let us continue with our class. No? Can anyone share with the rest of the class? No? What do you remember from our last lecture prior to the exam? Kung anong naalala nyo? Anong di-discuss natin? Anyone? Sige, Sunshine.
About sa legal po, sir, about yun sa mga property, tapos may asawa, may kabit.
Okay. Kasi I think you were referring to the property regime. Tama?
Yes, sir.
Okay. No? So, all right. No? What else? Meron pa kayo naalala? Okay, sige. So today, now we'll start our discussion with the concept of a contract. No, contract. Naririnig natin 'yan, no? Yung contracts, no? We hear this concept contracts because syempre Lagi natin sinasabi, pag halimbawa may bentahan ng lupa, by the way, sorry, I have to speak in English pala. If there is a sale of land, no, there is always that document where, which is a contract, no? A document which reflects all of the agreements or all of the stipulations of the parties, no? And we call that contract. Technically, you'll see the definition of a contract in Article 1305 of the Civil Code. In Article 1305, it states, a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. I will repeat. 1305 states, a contract is the meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So, if you look at it, that's the technical definition of a contract. So, you will note that in the definition as stipulated in 1305, there are certain key concepts which are meeting of the minds, for example. Meeting of the minds. Two persons. No? There is a binding. No? Binding. One binds himself with respect to the other. And then finally, you have the obligation, which is to give something or to render some service. So, when we talk of meeting of the minds, it means that there is a valid offer made by one party, and at the same time, there is an acceptance made by another party. So that is basically the general principle of the meeting of the minds. So somebody offered, okay, I will sell a property, and somebody agreed to buying that particular property. So that is the meeting of the minds. A contract is in a contract, there is what we call a juridical tie. No? As stipulated in the provision whereby one binds himself with respect to another. So it only means there is a tie. No? There is a juridical tie which binds the parties. And it only means that since there is a juridical tie, it means that the contract can already be enforced to the parties. No? So when a person gets into a contract, especially when that person signs a contract formally, it only means that the person willingly, without hesitation, should respect and honor the contents of the contract. It cannot be that you get into a contract or an agreement and then suddenly you decide to I don't care anymore. So because of the juridical tie that is part of the contract. And of course, a contract exists simply because there must be something, there must be something to give, or there must be a rendering of a service. So normally we get into a contract because there is a good that must be delivered. In our case, as real estate professional, what should we deliver? We deliver a piece of land, we deliver the key to a condo, we deliver the title, we deliver the document. As brokers or salesperson, what is what is it that we need to render, no? We need to render our service as brokers, as appraisers, as salesperson, as one who facilitates the sale, over a certain parcel of land, or over a certain property. So that is what is meant by to give something or to render some service. Is it what happens if um All right. Apologies on that. Clear ba ako?
Yes po, sir. Clear.
Yes, yes po,
Perfect.
sir.
Perfect.
Yes po, sir.
Sige. Wait. Okay. So let me continue with my discussion. So earlier I said that what if there is an offer, and the offer is not accepted. It means that there is no meeting of the minds. Why do I stress this? Because sometimes the mere fact that a person is offering, let's say, a certain parcel of land, no, or if not a condominium, no, and it's offering that property to another person, it does not constitute a meeting of the mind. What constitutes a meeting of the mind is that there should be a valid offer and a valid acceptance, meaning the other person also manifested that he is also interested, no, in purchasing or buying that property. No? What happens, Attorney RJ? What if when a person makes an offer and the other person um, um, accepts the offer under a condition? And when I say under a condition, it could be anything. No? It's like, okay, I will buy that, but I want that the let's say the bedroom should be bigger, or if not, I want that the furniture should be like this or should be like that. What, is there already a meeting of the minds? Not yet, no? Because when a person is receives the offer, the acceptance should also be complete and unconditional. Because if it is with a condition, that constitutes what we call a counter offer. So, if a person is offering, say, a condominium, and the seller is offering a condominium, and the buyer says, okay, I will buy the condominium under the condition that the payment shall be made in installment. Okay, so that it only means that the buyer is making a counter offer. And the only time that there will be a meeting of the mind is when the seller says yes to the counter offer. Okay, so clear on that so far? Okay, klaro naman siguro. No? So, in the definition, there is a mention of two persons. So, question. When you talk of two persons, meaning we're talking of parties. No? So, two persons actually means two parties. So, for a contract to exist, there must be at least two parties. So, a party can be one or more persons. Now, question. Are there exceptions to this rule when it comes to a person contracting to the rule that there must be at least two parties? One exception to this rule is the husband and wife. So let us remember that the husband and wives cannot sell to each other just because, of course, because this goes against the principle of the conjugal partnership of gains or the absolute community of property. Because anyway, the properties, especially if they are under the conjugal partnership of gains or the absolute community, things that they acquired during the course of the marriage, are also co-owned by them. So and hence they cannot sell to each other. Okay. Let us now go to a discussion on the elements. Let's go to the elements of a contract. There's what we call the essential element. There's also what we call the natural element. And finally, there's what we call the accidental elements. Christian, you're raising your hand.
Sir, I just want to clarify something.
Yeah, sure.
Difference ng conjugal and co-ownership is basically conjugal co-ownership siya ng married, ganun ba yun?
Sige. Let me recall. Let us recall the concept of conjugal partnership. Conjugal partnership of gains. So, when we say conjugal partnership of gains, it means that all properties acquired before the marriage remain as exclusive property of each spouse. Meaning, they own it exclusively. Meaning, sila lang ang may-ari nun, hindi kasama yung kanyang spouse. But all properties acquired during the course of the marriage, that becomes the conjugal property of both spouses. Nakuha niyo yun? Were you able to get that? That's conjugal partnership of gains. On the other hand, the concept of co-ownership, particularly in the case of people living together without the benefit of a valid marriage, they are bound by what we call the regime of co-ownership. What happens in the regime of co-ownership? In a regime of co-ownership, the owner of the property, all properties acquired during the period of co-ownership will be owned by the person who will be owned by the person who contributed to that property. So it means that if a person bought a particular car, while he or she is cohabitating with his partner, because he is the one who bought the car, he practically owns the property. In such case where that particular car was, both of them contributed to the car 50-50, it means that at the same time, they both own the property 50-50 as well.
Sir, so yung conjugal, pag sinabing conjugal property, is it the same as saying na they are co-owner of the property?
It's a conjugal partnership of gains. It means that first requirement there is it should be under a valid marriage. Number two, yes, all properties that is acquired during the course of the marriage, yes, it is assumed that they both own the property and hence 50-50.
Okay.
It's the same thing with absolute community of property. No, all properties acquired during the course of the marriage is also assumed to be co-owned by the spouses, including the properties that they acquired prior to the marriage. It's also co-owned. That's the concept of absolute community of property.
Medyo nalito kasi ako, sir, dun sa exam kasi meron dun parang two choices. Yung isa is conjugal property, yung isa is co-owned property. So parang kaya ako nalito.
In the exam. What was the question again in the exam?
Kalimutan ko na rin, sir.
Yeah, but I think the answer there is conjugal, if I remember correctly. The property, all properties, it is a it's a property regime wherein all properties acquired prior to the marriage is the exclusive property of each spouse, and all properties acquired during the course of the marriage is the conjugal property of each spouse. In co-ownership, always remember, there is no marriage. Okay, let me continue. Let's go. Earlier I said there are essential elements to a contract. And there is also what we call natural elements, and there is also what we call accidental elements. Let's start with essential elements. What do you mean when you say essential elements, Attorney RJ? It means that these elements must be present, otherwise there is no contract to be talked about. So what are these? Number 1, consent. Number 2, subject matter. And number 3, cause or consideration. So let's go through each. When you say consent, it means that the parties agree without any force, without any undue influence, and at the same time that they have the capacity, you know, to get into a contract. So consent may be expressed, or at the same time it could also be implied. Expressed meaning, when you say expressed, meaning the party in written, or if not verbally, said that they are consenting to the transaction, that they allow the transaction to happen. Implied, on the other hand, means that the consent may be derived from the overt acts of the parties. And when you say overt acts, we're talking to the actions, the behavior after the transactions. So like, for example, an example of an overt act, you know, in a real estate transaction, for example, an overt act may be, let's say, for example, there is no written agreement. There is no written contract of lease, but at the same time, you allowed a person for, say, 2 weeks to enter into your property, and every single day you ask for, say, daily rental. So although it is not expressly the lessor did not expressly say that he will allow a rental, no, but by his overt acts of collecting daily the rental income, that is an overt act that he consents to the rental agreement. So that one, consent. Another essential element would be the subject matter. So in the case of real estate, the subject matter could be the property involved. So we're talking, here we're talking of, in the context of contract, it refers to the good that must be delivered or the service that must be rendered. And then finally, the cause. So the cause is the agreement of the parties. Or it could also be the consideration, the payment that was made in compliance to the, let's say, a contract of sale. So that binds the parties. So those are what we call that is what we call essential elements of the contract. Now, let us go to natural elements. What do you mean when you say natural elements?
Sir, sorry, what is cause again? What is the abbreviation for cause again? Sorry.
The cause refers to the agreement between the parties. So, let's say the parties get into a contract and the cause itself, the agreement, the agreement between the parties itself, that is the cause for the contract. Sometimes, another way to look at these cause, sometimes they call it consideration. So that's why I also mentioned that sometimes the cause is the consideration. No? Why is it that there is a why? What is the what binds the parties? So, but generally, it is the agreement of the parties, the agreement to get into the that binds each other, the agreement that binds the parties together. Okay, natural elements. So essential elements, then you have natural elements. Natural elements of a contract include those elements which, although not included in the contract, are naturally part of it. Say, like for example, in a contract of sale, for example, there is an important element in a contract of sale is the warranty that the seller is actually the owner of the property. So, because warranties is part of a contract. The warranty that whatever it is that you're selling, actually, you're selling it because you own it. Otherwise, there is no point to selling a property that you do not own. So, natural element also may include the warranty against defects, for example. So, it is but natural to assume that when we buy a particular condo, for example, unless it was bought on an as is where is basis. I don't know if you're familiar with the as is where is basis. Unless it was bought in an as is where is basis, the warranty against defect applies. Meaning, if it will be turned over to us as the new owner of the property, everything should be in order. So that element is those elements are considered part of the natural elements of a contract. Are there other elements besides the essential elements and natural elements? One more. And we call this accidental elements. Accidental elements are those which are agreed by the parties and which cannot exist without stipulated. It means that these accidental elements, it means that it can only be considered part or element of a contract if it was stipulated in the contract. What are examples of this, Attorney RJ? Examples of this would include, say, let's say, for example, in the contract, there is a mention of, say, mortgage redemption. Meaning, if the buyer dies while while he or she was still paying for the condominium installment, the burden will be placed to an insurance company. So I say that this is an accidental element because these we normally have clauses or stipulations on the mortgage redemption um, in the contract itself. What else? Um, what other example of accidental elements? Accidental elements could also include, say, the payment terms. Um, for example, you stipulated that the 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 payment shall be made in installment, not just in cash. So, and you agreed that the payment in month one will be this amount, month two will be this amount, month three will be this amount. So, accidental elements. So, in case of natural elements as well as accidental elements, please note that the contract can actually exist even though these are not present. What must exist, however, is the essential elements. Absent any one of the three, consent, subject, or cause, the contract, uh, there is no contract. There is no contract or there is no valid contract. Now, there are three stages to a through three stages of a contract. Three stages. The first stage is what we call the preparation, conception, or generation stage. This is the period of negotiation, bargaining, ending at the moment of agreement of the parties. So it is that stage wherein the seller is making an offer with respect to his property, and the buyer is possibly making a counter offer. So in the what must be emphasized is that in the preparation stage or the conception stage or the generation stage, there is still no meeting of the minds. Hence, there is still no consent at this point. So there are just offers, there are just talks, there are just discussions. However, when it has come to a point where there is already a meeting of the minds, or there is that moment where the parties come to an agreement on the terms of the contract, we now call that stage as the perfection or the birth of the contract. The perfection of the contract or the birth of the contract. So at that point, my dear students, the contract is already born. The parties is already bound by certain responsibilities as well as certain rights. So is there a stage after the perfection of the contract? The last stage is what we call the consummation or death. What do you mean when you say consummation or death, Attorney RJ? It is the fulfillment or performance of the terms agreed upon in any contract. So, say for example, in the context of a regular real estate transaction, the consummation stage may happen at that point where the seller already delivers the keys and the documents to the property, and that the buyer also delivers the amount as agreed upon in the contract. Article 1306 stipulates that the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided that they are not contrary to laws, morals, good customs, and public order or public policy. So what does this mean, Attorney RJ? It means that where parties to a contract, including real estate contracts, real estate transactions, or yes, real estate contract, can actually stipulate whatever they feel will work for them. The only exception to this is when a contract is already contrary to laws, morals, good customs, public order, or public policy. So, in a contract wherein which concerns a parcel of land here in the Philippines, in that contract, that parcel of land is being sold to a foreigner, say for example an American, that goes against the principle of that falls, as an exception to the principle of autonomy of contracts. The principle of autonomy of contracts is that parties can actually stipulate whatever they feel will work for them. So, contracting parties may establish stipulation, clauses, and terms and conditions as they deem convenient. So, that's the general rule. The exception to the general rule, as in my example, is that except if it is contrary to law, to morals, good customs, public order, and public policy. So we all know that based on our Constitution, selling to a foreigner is against the Constitution. Because the Constitution provides that foreigners cannot own land in the Philippines. So in such case, while it is true that we respect the autonomy of contracts, it must still respect the laws, the valid orders of the Philippine Constitution. Let us now go to a discussion on the characteristics of a contract. What are the characteristics of a contract, Attorney RJ? The first one is obligatory force or obligatory character of contracts. What does this mean? It refers to the rule that once a contract is perfected, it shall be of obligatory force upon both parties. They are bound not only to the fulfillment of the obligation, but also to all of the consequences. Earlier, I mentioned that whenever parties get into a contract, it cannot be that the parties can easily disregard what was agreed upon in the contract because of the obligatory nature of a contract. So both parties must submit or must respect or honor what is written in the contract. The second characteristic of a contract is what we call the mutuality of contracts. Mutuality. What do you mean when you say mutuality, Attorney RJ? It refers to the position of essential equality that is occupied by both contracting parties. The contract must be binding upon both parties, and its validity or compliance cannot be left to the will of only one party. So it only means that where a contract, where parties bind themselves to a contract, the contract shall apply to both parties. So it cannot be that you will only enforce it to one party without enforcing it to the other. It must be enforced to the contracting parties. Next, autonomy of contract. This one is what I discussed earlier on the rule that the parties can actually stipulate the terms and conditions, whatever it is that they feel is convenient. So that's the principle of autonomy of contract. Again, the exception to the rule or to the principle of autonomy and contract is when the stipulation actually goes against public policy, law, good customs, morals, and public order. Next characteristic of a contract is what we call the relativity of contract. What do you mean when you say relativity of contracts? It means that contracts take effect only between parties, their assigns and heirs. So it only means that what is bound by the contract are only the parties involved. Meaning if you are a third party to a contract, you are not bound by it. Except, of course, if you are an heir or you are what we call an assign. When you are an heir or an assign, what happens is that all of the responsibilities as well as the duties of the party gets transmitted to you. The exception to this, of course, is where the transmission has been explicitly stipulated that transmission that will not happen to the heirs or to the assigns. So, absent such stipulation, it means that all of the rights, privileges, as well as the duties or responsibilities will really be transmitted to the heirs. Clear so far?
Yes, sir.
Okay.
Yes, sir.
Let's now go to classifications of contract. Classification. There are various ways by which we can classify a contract. The first way to classify a contract is to classify them according to their relation to other contracts. And here, we classify a contract as a preparatory contract, a principal contract, or what we can call as an accessory contract. What is a preparatory contract, principal contract, or an accessory contract, Attorney RJ? An accessory contract a preparatory contract are those which have for their object the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contract. So, an example of this, for example, in a real estate transaction, prior to the main contract, which is a contract of deed of absolute sale, us being brokers of the transaction, a preparatory contract may be a broker's agreement or a contract to sell. Because prior to selling a particular property, a party may acquire our services, as brokers. And as brokers, they will ask us to sign a preparatory contract called a broker's agreement or a contract to sell. The principal agreement in that case is the deed of absolute sale or deed of conditional sale in case of installment payment. So a principal contract are those which can subsist independently from other contracts and those whose purpose can be fulfilled by themselves. And finally, the last type of classification of a contract based on according to their relation to other contract is what we call the accessory contract. These are those which can exist only as a consequence or in relation with another prior contract. So let's say, for example, in a contract of sale, let's say that contract of sale, that property was bought via bank financing. So in such case, the loan agreement between the bank or the financial institution and the buyer can be considered as an accessory contract. It exists as a consequence only as a consequence in relation to the main agreement, which in that case, again, the absolute or the conditional deed of sale. Because absent a deed of absolute sale or a deed of conditional sale, there is no point to getting a loan agreement, because the loan agreement is actually you go through the agreement because there is a particular property that you want to buy. Another way to classify a contract is according to their perfection. So here, the classification of a contract may be consensual or real. What do you mean when you say consensual? Consensual are those which are perfected by mere agreement of the parties. So meaning the contract has been perfected by mere agreement. Which contrasts to another classification of property according to their perfection. We call it real contracts. Real contracts are those which require not only the consent of the parties for their perfection, but also the delivery of the object by one party to the other. So in this case, there must be a meeting of the minds, there must be consent, at the same time, there must be a delivery of the thing or the goods, or there must be a rendering of a service. Are there other classifications, Attorney RJ? Oh, there are still other classifications according to their form. So we have common contracts. those which require no particular form. And then we have special contracts, those which require some particular form. For contracts which require a particular form, you will notice this. We normally refer to these as pro forma documents. If you've heard of pro forma, it means that the form to that agreement, there's already a template or a guide or a sample, which could be the basis of the contract. The contract may also be classified according to their purpose. In such case, a contract, it can be a transfer of ownership, a conveyance of sale, or conveyance of use, or a rendition of a service. And then we can classify contracts according to subject matter. So it could be a contract of things or a contract of services. And then another classification would be according to the nature of the vindiculum which they produce. So here we can talk about what we call a unilateral contract or what we call a bilateral contract. A unilateral contract is those which give rise to an obligation for only one party. That's why it's called unilateral. So the obligation is only to that party involved.
Sir, sorry, pwede pa ulit yung sa subject matter? Ano ulit yun?
According to subject matter, things or services. Things, goods, diba? Ganun yun. And services.
Tapos sir, ano yung next? According to...
The nature of the vindiculum which they produce, or the nature of the tie or the juridical tie which they produce. So in case of unilateral contract, it gives rise to an obligation only to one party. On the other hand, we have what we call bilateral contracts. So when we talk about bilateral, from the keyword bilateral, so it only means it gives rise to reciprocal obligation. When you say reciprocal obligation, both parties are expected to deliver a good or to render something. So both of them has a responsibility or a duty.
So yung unilateral, one party lang yung required, yung obligated?
Yung unilateral, only one party. So as in the case of to be clear, as in the case of a donation, for example, one party out of his liberality or out of his generosity will donate a property and deliver said property to another. So that is an example of a unilateral contract. Now, a contract may also be classified according to their cause. So, according to their cause or consideration. So here, we can talk of what we call an onerous contract or alternatively a gratuitous contract. So what is an onerous contract, Attorney RJ? Basically, an onerous contract is one in which each of the parties aspire to procure for himself a benefit through giving of an equivalent or compensation. This is what I said earlier about the cause. So, in onerous contract, normally, there is an exchange of value. So, like say, for example, I deliver a condominium to you in exchange for, say, 2 million or 1 million. That is what we call an onerous contract because there is an exchange, there is a consideration. In contrast to a gratuitous contract, wherein those contracts wherein in which one of the parties proposes to give to the other a benefit without any equivalent or compensation. So, as in the case of a donation, for example, I will donate a certain parcel of land. No? And let's say I will donate it because I want to help the church or the public school. So in that case, that is what we call a gratuitous contract. So the donation of the parcel of land for a school is without any cost or consideration. So hence, it is gratuitous. Contracts may also be classified according to their names or norms regulating them. So, if it is a contract that has a name, or those which have their own individuality and are regulated by special provisions of law, we call those contracts as nominate contracts. Nominate. How does one easily distinguish or identify if it is a nominate contract? Normally, we call it a nominate contract because there is a title to the document. So like for an example of a nominate contract would be absolute deed of sale, conditional deed of sale, extrajudicial partition. Um, so here, special power of attorney. So in those cases, these are normal contracts or ordinary contracts that we generally produce every single time. No? And hence, there we as such, we already put a name to them, no? For easy reference. At the same time, because these contracts are normally covered by special laws. In contrast to a nominate contract, we also have what we call an innominate contract. Those which lack individuality and are not regulated by special provisions of law. So in such case of an innominate contract, basically it could just be any other contract that is usually special because we don't have a name for it yet. So but although we don't have a name for it, there are certain stipulations um, that the parties agreed to do. Sige, let's have a 10-minute break. It's 4:18. Let's have a break. Let's go back 4:28.
Okay po, sir. Thank you po.
All right, let's go back. So, yeah, let me just check if I've missed some very important principles. Okay. Let me just reiterate some very important principles on the characteristics earlier of a contract. So earlier, I mentioned about the autonomy of contracts, that parties can stipulate their terms and conditions, can stipulate what they feel is what they deem as convenient. The exception is that it must not be contrary to laws, morals, good customs, public order, and public policy. So, laws, very easy to understand. Those that are mandatory or prohibitive in character, of course, it must not be allowed. Let's say, for example, it's a contract to kill another person. Obviously, it's against the revised penal code to commit murder. So, that contract is not valid. When it comes with respect to morals, it means that those generally accepted principles of morality, which have received some kind of social and practical confirmation, synonymous to good customs. So, means when you talk about morals, let's say, for example, morality requires that you must not have scandalous behavior, let's say in public. Say being nude in public is not necessarily aligned with our customs, our morals. So, meanwhile, good customs, this principle of good customs, more or less, this is used interchangeably with morals. So, we refer to good customs as those that are accepted those that are acceptable to the community. Public order simply means that whatever it is that we agree upon, we make sure that it will always result to peace, safety, and health of the community. So, if, say, for example, we agree to buy and sell a property that will endanger the life of a client, so that is against public order. Public policy, on the other hand, the context is broader in scope than public order. It is defined as a principle of law which holds that no person can lawfully do that which has a tendency to be injurious to the public or against the public good. So everything that must be, all stipulations in the contract must be for the common good.
Sir, sorry, question lang po. Ano po yung main difference ng public order sa public policy?
Public order, public policy. Public order, we just refer to things that all stipulations must result to peace, safety, and health of the community. Public policy broader in scope. So like for example, we may not refer to the safety or the wellness of the public, but we may look into the let's say the economic well-being of the public. We may also look at the social implications of the stipulation. Like one example may be a certain real estate project that will deprive so many indigents because they will be displaced because of a real estate project. So that is a possible concern of public policy. So that is the reason why, as a matter of public policy, all subdivisions all developers are required to develop, say, low-cost housing. So that is part of public policy because we do not want to displace, or we want to make sure that the community, there's still that opportunity for the community to afford dwelling, which is a constitutional right. Meron pa ba? Parang so far so good. Okay. Sige. So, okay. Sige. So, let me just get a couple of shares. Now, what's your biggest takeaway from today's session? Ano nakuha nyo? Go, Alana.
Sir, yung mga characteristics of a contract, number 1 is the obligatory force, number 2 is the mutuality, number 3 is the autonomy, third is the relativity of contract. Those are very new to me, sir. Thank you.
All right, thank you. Next one. Biggest takeaway, guys. Any more takeaways? No more? Okay, Arfi.
Hi, Attorney RJ. Yeah, my takeaway for this afternoon discussion is all about the contract. It's very important, sir, to have whether it's a lease contract or a contract to sell, legality wise, especially yun nga naman, like you've mentioned earlier, if ever na may magpapastayin po kayo dun a certain property like a staycation for a week, or in other establishments po, it must have a contract po. So anything happens, may habol po si unit owner po or is a property owner po.
Okay.
Opo. Sir, I like your mas bumagay sa yung haircut mo today. Parang bumata ka po ng 10 years. Taray. Thank you, sir. Thank you, attorney. Bye-bye.
Thank you, Arfi. Yan, 'di ba? May mga may pa. Okay. Sige, no? So Okay. One thing that I don't also want to miss pala, no? The concept of, earlier I mentioned about the essential elements of the contract, which is consent, the subject matter, as well as the cause. My question pala sa inyo, no? Good point to emphasize lang. Does the contract have to be written in order to be valid? Anyone?
Yes, sir.
Sino yun? Explain.
Ano, sir,
Si
yes,
Marietta,
sir, it is
oh.
written.
Explain,
Yes, it is
Marietta.
written. Sabi nga ni Sir George Pimentel, yung meeting of minds daw, because of the meeting of minds pa lang, doon pa lang daw po, kahit hindi naman daw po ni-notarize, basta it is written, that is already a valid one.
So, ano yun? Paulit? Pag?
Kahit po hindi daw po na-notarize, basta it is written, it is valid.
Dito ko lang.
So, ang sinasabi mo, dapat written.
Yes, sir.
Okay. Any other dissenting opinions? Everyone?
Even verbal, basta nag-meet yung minds nyo, nag-agree kayo, that is valid lang.
Okay. Even verbal. Okay. Any other opinion? Mga hurado, judge and justices of the Supreme Court? Go ahead. Si Ernesto ba?
Sir Alvin Imukling po.
Alvin, go.
Sir, in general, pwede naman po yung oral contracts as long as they meet the essential elements of a contract like offer, acceptance, consideration, legal capacity, and lawful object.
Okay. So, correct. So, as a general rule, and this is something that I always emphasize, a contract, in order for it to be valid, doesn't have to be written. And hence, a contract, an agreement, a verbal agreement is still considered as a valid agreement. However, as in the case, as also stipulated by law, there is a concept called statute of frauds, which requires that certain contracts have to be written in order for it to be valid. And hence, there is a formal requisite. Such includes real estate properties or real estate transactions. So that is why, although as a general rule, contracts may not, in order for it to be valid, may not be written, in the case of real estate transaction, for it to be valid, it has to be written. So, something that you should also take into consideration. That is not just, and here I'm not just talking about sale of real estate, but also lease or rental of real estate beyond 1 year. According to the statute of frauds, rental of properties of beyond 1 year should also be written. And hence, if it is below 1 year, a verbal agreement is valid. Is that clear?
Sir, frauds?
Yes, sir.
Sir, statute of frauds?
Yes.
Sir, clarification.
Yes.
Sir, so sa donation, kailangan i-accept nung donee ba tawag doon?
donee, the donor and the donee.
So
There
pag
must
hindi-
also be an acceptance on the part of the... By the way, also in case of donation, in the amount more than 5,000 pesos, it also has to be written. In order for it to be valid. So, in case of donation, it is essential that although the donor offers the subject property gratuitously, the donee must also accept the donation. The acceptance may again be express or implied. Again, express or implied. In both cases, there must be acceptance. Who else would like to share takeaway for today? Meron pa? No more? All right. Sige. So let's continue our discussion next week. Now, thank you so much, guys, for attending today's session. I'm so happy to see all of you. I know it's Saturday, but you're here, you're committed, you're showing up. It only means that you really want to become a broker, appraiser, or consultant someday. So I hope you don't, you just continue studying. You stay passionate, guys. No? At the end of the day, I know that this might be a bit of a sacrifice for all of you, but let me reiterate, it will always be worth it in the end. Okay, so enjoy your weekend, everyone.
Thank you, attorney.
Thank you po. Thank you.
All right.
Thank you, Attorney.
See you next week, guys.
Thank you po, attorney.
Bye-bye. See you next
Bye.
week. Thank you, sir.